Guys, Stephanie Meek, Jaden Lee Meek's mother, remains in custody after the court denied to grant her bail for the death of her son, Jaden Lee Meek. Remember, she's facing 3 counts: defeating the ends of justice, crimen injuria, murder. Her lawyer tried very hard to poke holes on the investigator's statements, but unfortunately, he couldn't secure bail for his client, Tiffany Meek. Let's listen to the judge when she read out her bail evaluation, where she said to Tiffany, "No, I'm not giving you bail because you were dishonest right from the onset." Let's take a listen.
The state, in arguing the strength of the state's case, places reliance on the following considerations. A. Human behavior, like the conduct of the applicant. B. Physical evidence, like the school bag, pillow, and blood found inside the unit. C. Indirect evidence of witnesses, such as the security guards on duty. D. The state reminds this court that it is the trier of fact, not speculation or conjecture, and that evidence under oath can only be vitiated by evidence under oath. E. The state argues that the applicant is a dishonest person, and her attempts to explain crucial oversights, like the omission in her statement, Exhibit AA, that she returned to Swazi Place around 4 a.m. that morning, was both dubious and disingenuous. The state argued that because applicant was not aware of what evidence the investigating officer was going to tender, did she not prepare, and was blindsided by the detail of the recording of the happenings by the night security on duty in the OB. State argues that applicant intentionally omitted the time she returned to the flat that morning because she did not want it to play on the mind of the court that she returned to the flat, placed the body of the child outside in his underwear, because that was her trying to create distance between her presence and the discovery of the body. And even if the time as alluded to by the applicant is accepted, it does not change the fact that the body of the child was discovered after she left the complex and not before. If the state argues that applicant does not have a stable address, as the current owner, where her biological father resides, did not commit to a lease agreement in writing and can therefore evict them on a whim. Further, applicant can continue to work remotely from anywhere. Her continued employment is not attached to an address or conditions, thus being a flight risk is a possibility. G. The fact that applicant faces life imprisonment is a likelihood if convicted, making her a flight risk. H. The applicant endangering the safety of the public or disturbing the public order or undermining public peace is a likelihood. The state argues that the court should be mindful that the applicant did not give her mother's address here in Florida because she knows the community's anger and outrage if she dares linger within the borders of this province. The state submits that the online petition after the applicant's arrest reflects societal anger. It's as if the applicant was riding on the societal sympathy at the onset. However, now that the proverbial horse feels pain, it bucks and the rider is unceremoniously dismounted. The state argues that applicant has incurred the ire of society. It is exactly because of this that applicant, and not the investigating officer as argued by defense, gave the address in KZN out of fear of reprisal at the hands of the very community who supported her and even drafted a petition demanding justice for Jaden. Further, the applicant is at pains to explain how she will navigate traveling from Durban on a daily basis, given the continuous roles as set in the High Court, which will be the forum to adjudicate the trial. All the aforementioned will incentivize applicant to evade the trial, as argued by the state. The state therefore submits that the applicant has failed to show on a balance of probabilities that the interest of justice warrants her release on bail, and therefore bail should be refused for the applicant. Evaluation. This court is mindful with reference to the case of State versus Atchison 1991, bracket 2 SA, page 805, Namibian decision, where Mohammed J. said the following: an accused person cannot be kept in detention pending his trial as a fourth anticipatory punishment. The presumption of law is that he is innocent until his guilt has been established in court. The court will therefore ordinarily grant bail to an accused unless this is likely to prejudice the ends of justice. The court equally is mindful of the case of Ewan, where Stein J. remarked as follows: in regard to bail application, it is increasingly found that prosecutors and even magistrates regard themselves simply as the rubber stamps for the attitude of the police as to whether bail should be granted or not. The dangers of such a departure are clearly apparent. A strict independent adjudication of the facts of each case, which should include a careful evaluation of an accused's circumstances, the seriousness of the offence and the interest of the community, should be undertaken by the presiding officer in each case. The investigating officer's attitude is obviously a relevant consideration, but not the only, and certainly not the most important factor for a court to consider as to whether an accused ought to be granted bail. The question that begs answer is, what is the objective evidence presented of the likelihood of the eventualities envisaged in section 60, bracket 4 to 9, head with 8 capital A, occurring? In addressing the presumption of innocence, this court is mindful of the case of Conradi versus S, where the court referred to paragraph 14 in the Dlamini case 1999, where the Constitutional Court had decided that the presumption of innocence is indeed a peculiarly trial-related right, as evidenced by its entrenchment as one of the fair trial rights listed in section 35, bracket 3 of the Constitution. I therefore agree with Stein J's stated view that the presumption of innocence does not play a determining role in bail applications. A court seized of a bail application fulfills a very different function from a trial court. Its role is not to determine the guilt or innocence of the accused person. The bail court's concern with the interest of justice in the sense of weighing in the balance the liberty interest of the accused and the interest of society in denying the accused bail will, however, in most cases entail that it will have to weigh as best it can the strengths or weaknesses of the state's case against the applicant for bail. The presumption of innocence, therefore, is but one of the factors that must be considered together with the strength of the state's case. The state, in my view, in presenting persuasive arguments to gainsay that of the defense, correctly asserts that the behavior of the applicant on the day that Jaden allegedly goes missing raises more questions than answers, in as much as considered normal behavior can vary significantly. It still begs the question why, if Jaden was dropped off by the school transport around 3 o'clock, why was the alarm bells not sounded sooner? The applicant was seen by the day shift security leaving the premises smoking around 5:30. Any parent at that stage would be frantic, to put it mildly. Why then is a missing persons report only lodged between 7 o'clock and 8 o'clock that evening? And why is security only informed of Jaden's disappearance around 8:30? The state correctly, in my view, argues that there is no evidence to suggest that Jaden knew other people in the complex or, as a habit, will visit or play with other children in the complex, bearing in mind that they had lived there only for plus minus 2.5 months. This court has no challenge in accepting that Jaden was, as a fact, dropped off by the school transport that afternoon in question. Upon returning from the police station after the missing persons report was filed, why will applicant not return to a flat given the chance that the child could have returned home and finding no one there? Instead, she goes to her mother's place as she was devastated and emotional. This court deems it no coincidence that applicant omitted from a statement that she went back to the unit on the morning of 14 May to freshen up. The OB entry clearly stated that the applicant did not change her clothes and there was no bolt waiting outside as she simply walked away. At that stage, Jaden was still not found. Why is there such a persistence almost on the part of applicant to remain at the flat? in the likelihood of Jaden returning, if not to create distance between herself and the lifeless body of her child. Why else was applicant in a hurry that morning, according to the security guard on duty? Honesty in bail proceedings is of utmost importance, as the lack thereof may undermine the integrity of the bail system and is punishable by law. Courts are therefore more likely to deny bail if it believes that the applicant is not truthful and may be a flight risk or influence witnesses or interfere with investigations. The following ambiguous statements or factors were highlighted before this court with the sole purpose of creating doubt in the mind of the court and deflecting from the truth. 1. The fact that the investigating officer felt that applicant was not safe in the province, creating the impression that DECO came up with the address in Durban as an alternative. 2. Creating the impression that if the court grants bail and the applicant resides with the mother, that applicant can do so at her own risk, thus assuming the risk of being badly injured or worse, still killed. 3. That the applicant has an alibi. 4. The different descriptions of clothing, implying that the witnesses may be fabricating a version, whereas applicant maintains that Jaden did not wear the red school jacket on the day in question, but at least 2 people stated otherwise. 5. The fact that applicant approached the day shift guard at 5 o'clock that evening and he informed her that he did not see the child being dropped off by any transport, when in truth she never reported Jaden missing. That the guard made an entry of this report in the OB and she supplied him with her telephone number, informing him that she is walking to the shop to check for Jaden. Later, applicant's mother sent Mpo to take applicant to the police station, and again the contact numbers of Mpo and Hewen was recorded in the OB. When applicant, however, wanted to take a photo of the OB where the entry was made, it has mysteriously disappeared. 6. There was a suggestion that there are missing entries indicative of either tampering or destroying evidence. However, when the original OB was brought to court, this argument was abandoned. 7. Applicant will further say that it was in fact the night guard who saw Jaden in the vicinity of the complex only wearing a vest and shorts. This, despite the assertion that it, however, creates the impression that Jaden was outside Unit 13 at this stage. 8. Exhibit L, showing the bolt trip from Hull Street at 5:12 and applicant alighting at 5:22, does not succeed in creating doubt in the state's case. 9. Applicant was informed that the time of death was between 4 and 5 a.m. This is not confirmed in the post-mortem or anywhere else. 10. The school book inside the school bag contains the name of Jaden and his classwork for the day of 13 May 2025. However, applicant denies seeing a worksheet which undoubtedly states the name of Jaden Lee. 11. Applicant's instructions is that no one saw the pillow taken from her unit and placed in a forensic bag. 12. Applicant in the same vein instructs that Jaden suffered with nosebleeds, which blood could have been there for the past 6 months. 13. Applicant instructs that all the pillows in her unit have pillowcases, yet the pillow that was seized, noteworthy, had no pillowcase. 14. Applicant instructs that a certain social media personality made the statement that she made a video of the sniffer dog picking up a strong scent leading to the top floor of the complex, but that the police failed to follow through, thus accusing the police of failing in their duties. 15. Applicant instructs that the body was moved at least twice, and then the night guard placed the child's body closest to applicant's unit, it being 2 meters from a front door. 16. Applicant denies that Kamala's property was searched in her presence. 17. Applicant instructs that the red school jacket, as seen in the photo, was a spare school uniform jacket. 18. Applicant's instruction is that the underwear in the bathtub has been there from 5 days prior. This is peculiar given the evidence of applicant that the underwear was blood-soaked. 19. applicant's instructions is that the pillow was found inside a different flat, which was opened by the landlord after the dog picked up a strong scent. And that something like semen was found, but again the police refused to do their job. 21, applicant observed strangulation marks on Jaden's neck. However, this is refuted by the findings in the post-mortem report. 22, applicant instructs that the OB produced in court was not the book she wrote her details in, and that the OB in court was reconstructed. 23, if applicant knew she was a suspect, why would she not have disposed of evidence indicative of the fact that the evidence was planted and that applicant is being falsely implicated? This court is mindful, as was stated by Davis J., that justice cannot be served by sacrificing constitutional rights on the altar of outrage. However, objectively, Jaden had no defensive injuries, and the post-mortem informs that Jaden had a 6 centimeter by 5 centimeter deep skull bruise, indicative of force applied to the left temporo-occipital skull. The reddish abrasions indicates the freshness of the wounds, and there was no evidence to suggest sexual assault, as the applicant from time to time wanted this court to believe, hence alluding to the alleged blood-soaked underwear, which proved to be untrue from the photographs observed. Misleading the court has the consequence that an atmosphere and environment is created where it is difficult to trust the information presented. The applicant has shown that she has the ability to defeat or obstruct the administration of justice by causing other persons to be suspected and attempting to defeat or obstruct the cause of justice by placing Jaden's body outside her unit or stairs to create the conclusion that the child was harmed elsewhere. These inferences are consistent with the proved facts, and it excludes every other reasonable inference except for the one sought to be drawn. If applicant has the ability to deceive without hesitation, then surely the applicant has the ability to influence witnesses, especially her family. She will likewise also have the ability to undermine or jeopardize the objectives of the proper functioning of the criminal justice system. Her release will have the likelihood of undermining the public peace if the online petition is anything to go by. All the aforementioned, in turn, can incentivize applicant to evade the trial, especially in the absence of a fixed address within the borders of this province. In the case of S versus Jonas, it was held that the applicant would succeed if she is able to show by adducing acceptable evidence that the state's case against her is non-existent or subject to serious doubt. This is not the case in the present matter. The applicant failed to satisfy this court that she discharged the onus in proving on a balance of probabilities that the interest of justice permits the release from detention in terms of section 60, bracket 11b of the Act. Bail is accordingly refused for the applicant. Thank you. That is the ruling of this court. The matter is transferred back to Court J immediately for further dealings. Court adjourns.